seating. There's overflow seating in room 125. So if anybody's having a difficult time finding a seat, they're welcome to have a seat next door. This is the Senate Standing Committee on Health and Welfare, meeting number 12. The date is Monday, March the 28th, 2022. Madam Clerk, please call the roll.
Senator Rocky Adams. Senator Berg. Here. Senator Carroll. Senator Givens. Senator Harper Angel. Senator Howe. Senator Kerr. Senator Meredith. Here. Senator Nemes.
Present.
Senator Wise. Chairman Alvarado.
Here. Well, we have enough to start to get a quorum to get some testimony rolling and get some of these bills heard. We've got a pretty aggressive agenda today. We've got a lot of people that are here, and a lot of people that have signed up to speak. We're not going to have an opportunity to hear from everyone who's signed up. So I'm going to have a few folks on both sides of some of these bills be able to provide some testimony. We're also going to have some time limits on some of that testimony. So if folks are here, I know how sometimes what happens in our committees, people want to carry on and speak for a long period of time. I'm going to have my timer on, and when you hear that, we'll probably cut you off at that point. So please choose your words wisely and have your testimony be efficient and tidy when you come and present either in favor or against a bill. The first item that we're going to take up on the agenda is going to be House Bill 213, an act relating to occupational therapists. The sponsor is Representative D.J. Johnson. Representative Johnson, if you'd like to come to the table, introduce yourself and any of your guests for the record, and then kindly begin your testimony.
Thank you, Mr. Chairman, committee members, D.J. Johnson, 13th District, State House of Representatives. To my right is General Bullard. I'd like him to introduce himself.
Brigadier General retired Steve Bullard, Executive Director, Kentucky Commission on Military Affairs.
And additionally on Zoom, we have two individuals, Chuck Wilmarth and Nahali Kafas, who are available for questions only if you should have any technical questions. And with that, Mr. Chairman, I'll begin. So we're here today to present House Bill 213, which creates a new section of KRS Chapter 319A that will include Kentucky in an interstate compact for licensure as an occupational therapist. House Bill 213.
We have a motion on the bill and a second. It's very convincing testimony, Representative Johnson. Any other comments, questions for the representative? If not, Madam Clerk, please call the roll.
Senator Rocky Adams. Senator Berg. Aye. Senator Carroll. Senator Givens. Aye. Senator Harper Angel. Senator Howe. Aye. Senator Kerr. Senator Meredith. Aye. Senator Nemes.
Aye.
Senator Wise. Chairman Alvarado.
Aye. The matter passes with a count of 7-0. I'll entertain a motion for consent. A motion for consent and second. All those in favor, please signify by saying aye. Anyone opposed? All right. Congratulations, Representative.
Thank you, Mr. Chairman and members.
It'll be reported favorably to the Senate floor on the consent calendar. Next, we'll take up House Bill 730, an act relating to medical transports and admissions. The sponsor is Representative Josh Bray. Representative Bray, if you'd like to come to the table, introduce yourself and any guests that you have, and the floor is yours.
Thank you, Mr. Chairman and members of committee. I am Josh Bray, State Representative, House District 71.
Thank you. I'm Jeremy Rao, I'm the Rockcastle County Attorney. Thank you all for having me.
So what's before you is House Bill 730. It was at one point in time a part of a much larger bill dealing with 202A mental health transports. With the passage of House Bill 777 and the task force that will be formed this summer, we thought it was a good idea to study a lot of those issues then. What this bill simply does is it requests that the Cabinet redraw the 202A districts that are set in reg by October 1 this year, taking into account driving distance and patient load.
Okay. We have a major problem in Rockcastle County with patient transports for 202As, and we've had this problem for several years. They're threefold, I think, and this bill will solve those issues for us going forward. First of all, there's a great deal of hardship on the taxpayer, as currently we're having to transport patients from Rockcastle County to either Hazard, Harlan, or Prestonsburg, which is approximately either 3, 4, or 5 hour drive. We are only located about 50 miles from Eastern State in Lexington, so we would save a great deal in overtime pay for our deputies, plus gas money if we could have it redrawn to go to the closest location, which would be Eastern State. Further, it is a hardship on our deputies. Most of these transports happen after hours. That creates a great deal of overtime for the sheriff's department, plus takes time away from the deputies' time with their families. And then finally, it's a very big hardship on the individuals that we're trying to get help for. As county attorney, my office handles basically every 202A that comes through Rockcastle County. And then the sheriff's department's required to do transports. Currently, those individuals who need treatment, who are possibly going through maybe the worst day of their lives, or if not the worst day, very close to it, they're forced to sit in a police vehicle for several hours while they're having to go possibly to Prestonsburg from Mount Vernon, when we're just a 45-minute drive up the interstate from Lexington. And I think this bill takes care of that.
We have a motion and a second, and we understand a lot of these issues. It's permissive for the secretary to be able to make those determinations, which we appreciate that as well. We have a motion and a second on the bill. Any other discussion from members? If not, Madam Clerk, please call the roll.
Senator Rocky Adams. Senator Byrd.
Aye.
Senator Carroll. Senator Givens. Senator Harper Angel. Senator Howe. Senator Kerr. Senator Meredith. Senator Nemes.
Aye.
Senator Wise. Chairman Alvarado.
Aye. The matter passes with a count of 7-0. I'll entertain a motion for consent. Motion and a second. All those. Senator Carroll. Senator Carroll casts an aye vote. Senator Harper Angel, this is House Bill 730. I vote from Senator Harper Angel. All right, so the count is 9-0. We have a motion for consent and a second that's already been made. All those in favor, please signify by saying aye. Anyone opposed? All right, the matter is reported favorably to the Senate floor. Appreciate you all coming and providing testimony today, and it'll be on the consent calendar.
Thank you, Mr. Chairman. Thank you, members of the committee.
The members who've arrived here from education, appreciate you joining us. We've heard one prior bill to this, which was House Bill 213. Would you like to register some votes? Senator Carroll, Senator Harper Angel. All right, if not, we'll entertain. I vote for House Bill 213 for Senator Carroll. Senator Harper Angel. On House Bill 213 we heard earlier. I vote also. Very good. Well, the record will reflect that. All right, next on the agenda, we're going to hear House Bill 318, an act relating to juvenile justice. The sponsor is Representative Kevin Bratcher. Representative Bratcher, if you'd like to come forward, if you have any guests, if you could have them introduce yourselves, introduce yourself for the record, and please begin your testimony. And again, we're kind of on a time crunch with our committee today, so
Okay.
try to be as brief as you can.
We have one online on Zoom.
Very good. Again, whenever they're ready, if you could introduce yourself and all your
Okay.
guests introduce themselves.
Kevin Bratcher, State Representative, Louisville.
Josh Crawford.
Keith Talley, Chief of Community Building, Louisville Metro Government.
I understand there's several judges online. If you could introduce yourselves.
Go ahead, Steve.
Gold, I'm a Henderson County attorney.
Judge Karen Thomas, Campbell County District Court.
Judge Micah Pence, Barron and Metcalfe County Family Court.
Very good. Please proceed.
Thank you, sir. There's an unfortunate rise in crime across America, and that includes juvenile crime. House Bill 318 here addresses some of those problems. This bill will also, and this is important, will also help good guys like the guy to my right here reach young folks before and try to turn their lives around. And I'm going to go ahead and let him get started, Keith Talley.
Make sure you hit. There you go. There.
Thank you, Mr. Chairman, committee members. We do have an unacceptable level of gun violence in Louisville, and we are seeing an increasing rise in that gun violence being perpetrated and the victims being juveniles. One of the ways that we combat that is trying to get out in front of those juveniles. And so we have a program, Group Violence Intervention, where we have the opportunity to go out and get in front of these individuals and talk to them. Those that are most violent on the street, those that LMPD Intel tells us we need to get in front of. We also have a program called CPRVVs, which are community police response to victims of violence. And in those cases, and in case of a gun violence, we will show up at the hospital at the time those folks are being treated, so we can get in front of them, in front of family. And what we're trying to do is get in, to stop any retaliation and to de-escalate that situation as soon as possible. One of the situations we have when we have juveniles picked up for serious offenses is when they are cited and released, or we don't have a chance to get to them. And what this bill does is gives us that 48-hour period to get in front of these individuals to do two things. If they're at risk of being a victim, we get a chance to de-escalate, find out if we need to move them, see what services we can provide them, and if there's an opportunity that they may retaliate, we have a chance to get in and de-escalate that situation. Putting them back out on the street within 3 to 6 hours of them being picked up is putting those individuals right back in that environment that we're trying to protect them from. And so that is the overriding ask that we have. The other thing that it does ancillary to that is it keeps our police officers. Louisville is currently in the neighborhood of 200 to 300 police officers short. And so a lot of vacancies, staff is stretched. And so when police officers are with these kids and they have to spend 3, 4, 5, 6 hours with them, that's 3, 4, 5, 6 hours that they are not on the street doing their job. And so trying to alleviate some of that problem. We think the court designated worker process is a good process. We want to work with them in that regard, but we really would like to address these two issues in terms of dealing with the gun violence in Louisville.
Steve Gold is next.
Thank you, Representative Bratcher, and thank you to Chairman Alvarado for allowing me to appear remotely. My name is Steve Gold. I'm the Henderson County Attorney. House Bill 318 makes some changes that will have a positive impact on our youth and the juvenile justice process. I'm going to focus my testimony on what it does in that middle part of the spectrum of juvenile justice. It closes some loopholes and provides specific rights to two categories of juveniles. First, it provides a time limit for truancy cases, says how long they can sit without coming before a court. Truancy cases are often referred to a pre-court entity called a FAIR team, which stands for Family Accountability, Intervention, and Response. Some truancy cases have languished at the FAIR team level to the detriment of the student because the process is not particularly well defined in the statute as to what exactly they can do and how long they can attempt their interventions. House Bill 318 is designed to give the FAIR team an opportunity for intensive interventions, but to put some time limits on just how long it can keep a case before allowing the youth the right to have a family court judge hear the case. Over the last several years, I've observed that this loophole has contributed to kids missing so many days of school that the case, by the time the case goes to court, that the kid has lost an entire academic year. Second, House Bill 318 ensures that young people are not failed out of the court-designated workers diversionary program merely due to lack of cooperation from a parent or a guardian. As part of the diversion process, a youth may be required to attend some sort of counseling or other appointments, particularly those who cannot drive or dependent upon a parent or guardian's cooperation in order to meaningfully participate in these therapeutic programs. In some cases, they end up failing out of the diversion and the case is sent to court through no fault of their own. House Bill 318 allows a court-designated worker who identifies lack of cooperation from a parent or guardian as the sole reason the youth has failed the diversion and send that case to the court with that notation. At that point, the court has the option to place the parent under court orders and to cooperate and then refer the case back to the CDW to complete the diversion. House Bill 318 also closes a probation loophole that in many cases only serves to prolong the process and undermine accountability. Juvenile probationary periods are relatively short, usually 6 months or less, and they keep running even if there are further violations of the law. So a youth who has continued to violate the law often uses legal maneuvering to run out the clock on the probation and avoid any consequences. In fact, we often see defense counsel file motions to get cases continued, and then they advise their client to admit to the allegations in the petition as soon as the probation period has expired. This type of loophole generally does not exist for adults and should not for juveniles. It ends up eroding accountability for our young people and in the end does them a disservice. House Bill 318 merely tolls the running of the probationary period for the youth if there's a pending probation violation, which allows the court to impose some actual accountability for bad acts. The Kentucky County Attorneys Association urges passage of House Bill 318. Thank you for your time.
And Josh next.
Thank you, Mr. Chairman, members of the committee. Unfortunately, 2021 was the deadliest year in Louisville's history, with 188 homicides, up from 173 in 2020 and 116 in 2016. 641 Louisvillians were non-fatally shot that year. That included 123 children, 24 of them fatally. 11% of murder cases resulting in arrest in Louisville in 2021 had a juvenile defendant. The national number is 8%. Unfortunately, these numbers are even worse for carjackings. Carjackings in the city of Louisville increased 306% between 2019 and 2021. In 2020, 51% of all arrests for carjackings were juveniles 17 and under. In 2021, that number was also 51%. That's up from 40% in 2019. House Bill 318 deals with the most violent offenders and holds them accountable for their actions by imposing an up to 48-hour time period by which they could see a judge, and they're detained during that time period to keep them out of the kind of trouble that Chief Talley talked about. The question has been raised, what does any of this have to do with truancy? Truancy is a statistically significant predictor of further delinquent behavior and adult criminality. Truant youth are 2 times as likely to have any conviction by age 50 as a non-truant child. They are 2.5 times as likely to have a violent conviction relative to a non-truant child, and they are twice as likely to engage in problem drinking by age 18 versus a non-truant child. Thankfully, in large measure because of previous reforms that this body has passed, Kentucky is making significant improvement in improving truancy outcomes. House Bill 318 will not change that process for the overwhelming majority of truancy cases, the successful cases that exist already. But for a child who makes no progress within 30 days, they will have to see a judge, and as Steve Gold indicated, if they are failing that process, not because of any doing of their own, but because of a non-cooperative parent, that parent can be mandated to participate in the process. Well, why care about such a small minority of cases? Well, unfortunately, juvenile delinquency, like adult criminality, concentrates among a very small number of individuals. About 4 to 8% of juvenile offenders are responsible for more than 50% of juvenile offending. These are our highest risk kids. These are our toughest cases. House Bill 318 will help address that issue specifically, those violent offenders and those kids before they make the biggest mistake of their lives by pointing a gun at somebody and pulling the trigger. Thank you.
And if I could say one thing, Chairman, you know, this is across the Commonwealth. This isn't just Louisville, but everyone knows what some of the issues Louisville's going through. And it's quite easy to bash the mayor these days. Well, here's the mayor coming to us, asking us to help him. And so I don't know how we could turn that down. So I hope we could pass this. Thank you.
All right, thank you. We have a motion, and we have a second on the bill. Any discussion or questions from members of the committee? Senator Givens.
Mr. Chairman, I do suspect we have others that are going to testify. Is that correct?
I don't have anyone else that's signed up. I think the judges may want to testify or provide some testimony. Judges, are you there?
Before they testify, if I could
Yes,
ask a
Judge.
question
Please.
Mr. Gold, I believe it is. Can you hear me, sir?
Yes, sir.
Okay, thank you. I think you're Henderson County, is that correct?
Yes.
And I think you're testifying in favor of the legislation, is that correct?
Yes.
Okay. It just strikes me as a little odd. I was reading online a quote from you saying Henderson County's efforts to address and prevent juvenile crime have been praised as a model for the rest of the state. Juvenile crime in Henderson County has been reduced by over 2/3. And I was curious if you're seeing adverse effects of the current law right now, and how have you been able to move so successfully in Henderson County under the current law?
Well, I will say that what Senate Bill 200 did in 2014 is, frankly, a lot of kids that probably should not have been going to court on that far nonviolent part of the spectrum. What we found in Henderson is that too many of them were coming to court and being involved in that process. And that can actually be detrimental to a youth when they should not be involved in that process. So what we were able to do a little bit before Senate Bill 200 came into place, we were able to put some additional diversions in that would keep those nonviolent youth from coming to court that probably should not have been. What we do see though is, now that all the small trees and brush have been taken out of the forest, now we still see some of these big trees that make up the forest. And so there is still violent crime, and there's still youth doing some very serious antisocial acts. And I believe other parts of House Bill 318 deal with that. Particularly the ones that I'm focused on are having some meaningful probation. The fact that it's not told for a youth while they continue to commit violations is a problem. Having a case where it does not languish at the fair team level for too long, and where that youth can have a right to get in front of a judge and have that case come to court is important. And then the issue where we have parents who are not participating. A youth should not be held responsible for their parent or guardian's inability or not inability. That would be up to a judge to determine whether they had the ability. But a youth should not be held responsible if their parent just doesn't care enough to participate in those diversions. They have a right to those diversions, and if they're being failed out of those diversions merely because they will not do transport or get them to appointments that they need to be at, this allows a judge to say, parent, guardian, you need to get this youth to these meaningful interventions to where some actual therapy and some therapeutic things can be put into place. And I think that's really important so we can head off some of these more violent things that occur that we're hearing about from the folks from Louisville.
Mr. Chairman, thank you, and I look forward to the judge's testimony. Thank you.
Thank you. Senator Adams, you have a question?
Thank you, Mr. Chairman. I do. Has a fiscal impact statement been prepared for this bill? I know it will be a local mandate.
No.
Thank you.
Judges, if you'd like to provide your testimony just very briefly, we'd appreciate to hear from you.
I think I'll start. I'm Judge Micah Pence, and I'm a family court judge in Barron and Metcalfe County. So I'm in the South Central rural part of the state. And I just want to say thank you, first of all, for allowing us to testify today and for bringing up this bill. These are issues that we are all dealing with, but we're all dealing with them in very different ways. The reality is, whether we want to talk about it, the pandemic anymore or not, the pandemic has affected detention and school attendance more than any other areas. It's been touch and go of could we detain someone, or is that facility locked down because of COVID? What is considered attendance? Is it logging onto a computer, or is it something else? And I state those two things because that really sets the stage for how much difficulty we've had in these areas as a court system over the past 2 years. The reality is, with truancy cases, I don't deal with any status offense cases or juveniles committing crimes other than the truancy cases. And the problems that we're seeing now are the cases that I'm finally having come before me. We've got issues with quarantines, that the child was quarantined for 10 days because their sister at the elementary school was quarantined, yet that was counted against the high school student that also had to be quarantined for 10 days. And I think we need the opportunity to let some of those things shake out and to have a meeting and regroup after this school year. But the other issue with truancy, and specifically with them coming before the court, I could not agree with the county attorney of Henderson more. It can be detrimental for a youth to come before the court. I'm scary as long as you've not been before me. When you can threaten a youth with the judge, and that can be the bad cop, that is advantageous. But if we bring them to the court and to the judge too early, you no longer have that threat hanging over their head. I need to know when a child comes before me, it's because we've tried absolutely everything else first, and that you're ready for me to either send them to detention or take some greater step. We need to try everything else, such as therapy, first. So moving these children automatically after 30 days of no improvement, which is just not clearly defined. Is that one absence? Is that 30 absences? these are decisions that need to be made on a child to child basis. The other issue that I have with this language, again, these are unintended consequences that I can see coming before us. But concerning the parents who aren't willing to participate, there's a separate statute. If the parent is the problem and the parent is not cooperating, then we should never be charging a child in the first place with truancy. If a parent is failing to provide their child with an education, that is neglect, and neglect under 600.020. Our CDWs are not built to deal with parents' issues. They're simply built to help the juveniles. The Cabinet for Health and Family Services, on the other hand, is built to deal with those problems that arise from the family setting and from the home. And that's what we need to be triggered. My DPPs and I have worked very closely through this pandemic. And one of the big things that I have urged them to do is, instead of going through truancy, if the parent won't respond or won't cooperate, that is a dependency, neglect, and abuse case. And if you'll file that, because they don't have to wait to file educational neglect. Any DPP or any person can file that at any time. But that brings in some very important resources, including a guardian ad litem to represent the best interests of the child, instead of bringing in DPA, who's ready to deal with a criminal case. You bring in a GAL and a social worker from the cabinet who can better deal with the issues of what else is going on in that home. It starts with educational neglect. That's often what gets it before us. But normally, if a parent isn't responding, there's much more going on in that home
Thank
than
you,
just.
Thank you, Judge. We appreciate that testimony. Judge Thomas, have you got it very briefly, because we've got a pretty heavy agenda. Anything you want to add just in 2 minutes?
Yes, very quickly. One, I think we have to be aware that while the system works the way it does right now, and I understand the concerns, by requiring the child to come all the way to court with the parent for the parent to be told to behave and take care of their child, we are losing valuable time to help those children, versus allowing the DPPs or the FAIR team themselves to refer this matter to DCBS, so that DCBS can do its job and start looking into see why this is happening to the parents and the child, and see if we can get assistance and resources for the child. My other point to make very quickly is on the detention piece. What we are talking about in the data that I've looked at, courtesy of AOC, seems to indicate that there's a large portion of these violent offenders that were actually never arrested. So there wasn't a detention issue because the police officer or the county attorneys in these various jurisdictions, maybe not Louisville's, but in the various jurisdictions, other jurisdictions, made the decision not to charge the child in such a way the child was arrested. Just like with any other charge, it has to have a process attached to it. And if you have a complaint, the officer, yes, certainly can arrest on a felony, a probable cause on the felony, but the officer, or the county attorney's office for that matter, has the opportunity to try to work with the family to engage in investigation. And if the child and family are cooperative, a lot of times is what you see is the child is summoned into court along with the parent. Maybe the child's engaging in treatment, much needed treatment. And that's why the officer in the county attorney's office have taken the position. There's safety in place and so forth. The statute, the way it's written, would require all offenses, not just those that are actually arrested and to be held for review by a judge, but every violent offense to be actually held in detention. And what we're doing is stopping our ability to help our children from at the point where we first have contact with them. And that's what officers are doing. And that's what county attorneys are doing. So I really would like an opportunity to sit down with Representative Bratcher, who I totally understand why all of this is happening. And I think it's something we need to talk about. But if we could spend some time looking at the data and the data for across the state and try to work through some of the issues we have with all of our community partners, I think we're better served, and we better serve our children that way.
Thank you,
Thank
Judge.
you for the opportunity.
Thank you. Appreciate the testimony. Any other questions from members of the committee? If not, we have a motion and a second on the bill. Madam Clerk, please call the roll.
Senator Rocky Adams.
I'd like to explain my vote, Mr. Chairman.
Please proceed.
Mr. Chairman, this is a difficult one for me because I really respect Representative Bratcher. I think he's done an outstanding job. And we have, people that I respect on both sides of this issue, trying to make a determination about how we stop this very real problem of juvenile violence that we are experiencing, particularly in my my city of Louisville. But there's still a few things that I think I need to figure out before I can cast a vote. I'm a pass right now. I mean, I worry about that we don't have a fiscal note on this yet. The juvenile detention center in Jefferson County has been closed. Where are we going to put these kids? How many of these kids is it actually going to impact? And so I look forward after this committee meeting, kind of getting with both sides and seeing if I can't put some meat on the bones and feel more comfortable once we tackle it on the floor.
Thank you.
Senator Berg.
Explain my no vote.
Please proceed.
Thank you, Mr. Chairman. I have a couple of real concerns about this bill right now. One is the discussion of truancy, which I don't think at this point, as we're coming, God willing, out of this pandemic, I don't think the last 2 years is an adequate reflection of what we should expect to have. So I'm just not sure that we need to fix something right now that was in large part, I think, affected by the pandemic, and we need to get over it to find out where we are. I really appreciate the desire to have these children in a place where they can be evaluated and they can start getting the wraparound services they need. And I think from what I'm understanding, that was part of the background of this bill, was to be able to offer a situation that would have a positive therapeutic impact. But again, I don't think we're there yet. We don't even have a building to house these children. They're being sent 2 hours away frequently. Just for now, I am a no, and this is something I really would like to address more over the interim and see if we could come up with something that would be agreeable to all. So thank you.
Senator Carroll.
Explain my aye vote, Mr. Chairman.
Please proceed.
Coming into the meeting, really had no doubts about being an aye vote. It's kind of ironic because some of the points are the same on both sides of this issue as far as getting help to the child. And there are parts of this bill that I like, parts I don't like. And so I look forward to further discussion within the caucus, and I reserve the right, as always, to change my mind on this, but I do appreciate all the efforts. I'm a little bit troubled that all the testimony in favor of the bill has been all about Louisville, Jefferson County, and I've talked to a fair team member from my district. We have a very successful fair team in my district, and I think this is really two separate issues with what's going on in Louisville, Jefferson County, and I'm really concerned about how this might affect the rest of the state, especially those of us in rural areas. So those are the things that I look to discuss between now and if it comes to a vote on the floor that time. Thank you, Mr. Chairman.
Senator Givens. Senator Harper Angel.
Explain my vote, Mr. Chairman.
Please proceed.
I vote no, and I want to reiterate the fact that I have the utmost respect also for Representative Bratcher, but I feel like the bill needs more work and would be better served in working with the Judiciary Committee, maybe in the interim. So for that reason, I have to vote no at this time.
Senator Howe.
Explain my vote.
Please proceed.
First of all, I want to thank Representative Bratcher for bringing this bill. This touches on a lot of things that we're having trouble with. I do not live anywhere close to Jefferson County and can speak independently of that, Mr. Chairman. We have a lot of problems with truancy in our areas, and sometimes the kid is only as troubled as the parents allow them to be. I really like the accountability setup that directs more toward the parents in this bill, and I like the fact that the violent offenders can be held for 48 hours right after commission, not just to protect others around them, but to protect themselves too. A lot of times we have some mental health issues and that sort of things that are the underlying causes of the child's action. Oftentimes those go untreated and uncovered, and I like being able to secure that child for a period of time so we can address the issues. I vote aye, and thank you again for bringing this.
Senator Kerr. Senator Meredith. Senator Nemes.
Aye.
Senator Wise.
Explain my vote, Mr. Chairman.
Please proceed.
Thank you. I vote aye. I also want to say that if you talk to school administrators and school personnel, I know I have over the last few years, they will say that truancy issues and a lot of things that happen out of Senate Bill 200 may have been unintended consequences, but I think we have to give this serious consideration of things that are happening across the Commonwealth. This happened long before COVID, of some things that need to be tightened up and loosened. And so, Representative Bratcher, I thank you for this bill. Thank you, Mr. Chairman.
Chairman Alvarado.
I'm going to explain my aye vote. So, Representative Bratcher, I have tremendous respect for you. So, I'd like to see this bill at least come through the committee process. So I'm casting a vote for that purpose. I know back home, a lot of my judges don't like this bill. They've reached out in opposition. My county attorneys are supportive. So I'm not an expert. This is not a judiciary committee, as you know. It's health and welfare. So for me, this is kind of beyond my wheelhouse. So I rely a lot on people back in my district. I know the current system we've got is, according to the people I've talked to, works pretty well in my district right now. And I know that this is different in different pockets of the state. But out of courtesy for you, Representative Bratcher, and for your work on this bill, I'm going to cast an aye vote to be able to get it through committee. I reserve the right to be able to change that vote on the floor. And I know there's going to be some other discussions, it sounds like, on this bill from people in support and people against it. So with that being said, the final tally is 6 yes votes, 3 no votes, 1 pass vote. The bill will pass favorably with favorable expression of the Senate floor. We appreciate you all coming today.
Thank you, Mr. Chairman.
Thank you. All right, next on the agenda is House Bill 7, an act relating to public assistance. Oh, Senator Wise, do you want to register a few votes?
Thank you, Mr. Chairman. Sorry for my absence being in the Education Committee. I'd like to cast an aye vote on House Bill 213 and an aye vote on House Bill 730. I don't think it changes the record. Thank you.
Thank you. Anyone else? All right, so on the agenda we have House Bill 7, an act relating to public assistance. The sponsor is Speaker Mead. We have on this bill before us a committee substitute, and we'll entertain a motion on that sub at this point in time. There's a motion. Is there a second? You have a second. All those in favor, please signify by saying aye. Aye. Anyone opposed? All right, the sub is before us. Also, I want to point out to members there was a technicality that was found. And so there's an amendment for this sub. On page 57, line 4, we're deleting the word public assistance and inserting Medicaid. That change was made throughout the sub, but it was missed as we were reading it. So this is an amendment to clean that up. I'll entertain a motion on that amendment. There's a motion and a second. All those in favor, please signify by saying aye. Aye. All right, so we have the sub as amended before us. Representative Mead, please proceed.
Thank you, Mr. Chairman. I'm not sure if the speaker's abandoned me or what's going on here. No, I'm just joking. He had a phone call he had to take, so he's outside. We'll be back in just a few minutes. But I'll start going through the bill, and I'll try to move as quickly as possible. I know we have probably a pretty lengthy discussion on this. I'll go section by section, starting with section 1, and this creates a new section of statute to clarify the terms cash assistance and public assistance as used in this act do not include foster care payments, kinship care payments, fictive kin care payments, or relative placement payments. Section 2, require the Cabinet for Health and Family Services to establish and maintain policies and practice necessary to ensure compliance with federal law, which prohibits the use of cash assistance benefits to purchase certain types of products, including alcohol, tobacco, etc. Require that if cash is withdrawn from electronic benefit transfer cards, those funds must be used to purchase items and services necessary for the welfare of the family, and establish penalties for violations of this section. The penalties that are established are changed some from the original House version. They are 1 month for the first violation, 3 months for the second violation, and 1 year for every violation afterwards. Section 3 affirms the mission of the SNAP program and encourage SNAP beneficiaries to use their benefits to purchase healthy foods, and require the Cabinet to coordinate with the Department of Agriculture to expand access to farmer markets by SNAP beneficiaries. Section 4, establish SNAP transitional benefit alternatives. Those are developed for families transitioning off of TANF and KTAP, and those benefits will continue to receive food assistance for up to an additional 5 months when they transfer from those programs. Also requests a SNAP Elderly Simplification Application Project waiver from the U.S. Department of Agriculture. This is limited to seniors with no earned income and also can include disabled households with no earned income. This is a simplified application form that will be used, and certification of these benefits will be extended from 1 year to 36 months, and the requirement for recertification interview has been waived. Requests a SNAP standard medical deduction waiver from the U.S. Department of Agriculture. Right now, those beneficiaries on their taxes, they have a $35 per month. If the expense is more than $35 per month, then they can take that deduction. But what we're saying here is we're going to establish a $150 standard deduction, and they would have the choice between those two. Section 5 requires the Cabinet for Health and Family Services to implement a community engagement program for able-bodied adults without dependents who have been enrolled in Medicaid for more than 12 months. Require implementation of this act no later than April the 15th of 2023. Section 6 creates a new section of statute to prohibit the Cabinet for Health and Family Services from establishing a basic health program without first obtaining specific authorization from the General Assembly to do so. Section 7. The Cabinet is to continue to conduct eligibility redeterminations as in the normal course of business and act on those redeterminations to the fullest extent permitted under federal law and after the expiration of federal restrictions. Currently, right now, under federal guidelines, anyone who has been placed on Medicaid, whether that they are ineligible or not, they cannot be removed from the rolls due to maintenance of effort. So this just simply says that they will keep track of those, and immediately upon the lifting of those restrictions, they will start to remove those who are ineligible, and we'll have that completed within 12 months. Section 8, prohibit the Cabinet and Department of Medicaid Services from being designated as qualified health entities for the purpose of making presumptive eligibility determinations. Section 9, to establish the responsibilities of hospitals when making presumptive eligibility determinations. This is a language that we worked on with the Hospital Association. They came back and gave us language that they felt could add some regulations to them and also hold them accountable when that is not being used properly. Section 10 requires Medicaid coverage for substance use disorder treatment for incarcerated individuals. Section 11 permits a custodial parent who is disqualified from receiving cash assistance benefits to designate a protective payee to receive cash assistance benefits on behalf of that dependent child. Therefore, no child will ever lose the benefits. Section 12 require the Cabinet to update LRC on implementation of the Act. Section 13 authorizes the Attorney General to enforce the chapter and bring action against the Cabinet if provisions of this Act are not appropriately implemented. Section 14, direct the Education and Workforce Development Cabinet to establish a job placement assistance program for individuals enrolled in Medicaid. The Cabinet will give the Economic Development Cabinet the names of those who are able-bodied individuals that are without dependents. They will then have the opportunity to participate in this job placement assistance program, which will be one-on-one assistance. The Cabinet will partner with companies out there to employ folks, and they will also put a focus on those employers who are offering health care benefits. Section 15, prohibit the Cabinet from seeking, applying, or renewing any waiver of SNAP work requirements without authorization of the General Assembly to do so, except in counties where the unemployment rate is equal to or greater than 10%, or if the statewide unemployment rate is equal to or greater than 10%. Section 16, prohibit the Cabinet for Health and Family Services from accepting self-attestation of income, residency, age, household composition, caretaker or relative status, or coverage for the purpose of determining Medicaid eligibility without verifying the information prior to enrollment. Self-attestation would still be permitted, but the Cabinet would have to verify that information prior to enrollment instead of after enrollment. Residents of an assisted living facility or long-term care facility are exempted from this requirement, and it requires the Cabinet to use only the most recent income verification data available when determining eligibility for public assistance programs, and permit the Cabinet to consider fluctuated employment income and establish penalties for trafficking EBT cards. Those penalties have been changed again from the House version. There are 3 penalties. One, the first strike would be 6 months, the second time would be 12 months, and the third time would be 5 years. Section 17 amends statute related to appeals of eligibility determinations, and as amended, an individual disqualified from receiving public assistance would now have access to standard appeal processes. Section 18 requires the Cabinet for Health and Family Services to notify the General Assembly of the reason for a denial of a waiver and directs the Cabinet to reapply only if directed by the General Assembly to do so. Section 19 requires the Cabinet to take appropriate action, including enforcement of relevant federal regulations to assure that responsible parent or parents of a needy dependent child provide support for that child. Permit the Cabinet to waive such requirements in the case of child abuse, domestic abuse, or if the Cabinet determines such actions would not be in the best interest of the child. Sections 20 to 32, This amends various sections of KRS to delete references to the Child Welfare and Medicaid Oversight Advisory Committees, and these sections are incorporated into Senate Bill 43, which has been rolled into another bill that was passed out of the House last week and over to the Senate. It's prepared for concurrence. So we are adjusting that language to match that. Section 33, the Child Care Assistance Program, the Cabinet is going to do a study or give us numbers on the Child Care Assistance Program and assessment of additional costs the state incurred by increasing the eligibility to 200% of the poverty level, and an assessment of what the fiscal impact of discontinuing multiple co-payments for families with more than one child in CCAP no later than September 1st of 2022. We need this data in the Public Assistance Task Force that we'll be creating so that we will know the costs of this program as we compare that to things that we would be implementing with that task force. Provide the Interim Joint Committee on Health and Welfare with a report of the fiscal impact and cost of utilizing a single benefit transfer card for public assistance recipients, and contract with an independent third party to review all presumptive eligibility determinations made since January 1st of 2020 for compliance with all applicable state and federal laws related to presumptive eligibility, and require the third party entity to submit a report to LRC no later than June 30th, 2023. This is a recommendation that came from Senator Givens. What we will do is do a data keeping on presumptive eligibility of each individual hospital across this state. They will be ranked, and we will have exact data on how each one of them did over the course of the next few months and years. Section 34 requires the Cabinet to seek a federal waiver for any authorization that it needs for this act. Section 35 directs all the Legislative Oversight and Investigations Committee to conduct an in-depth analysis of TANF and KTAP spending and identify alternative sources for child welfare funding. In sections 36 to 40, directs LRC to establish a benefits cliff task force to review the impact of public assistance benefits cliff and make policy recommendations and support working families in transitioning off of public assistance into gainful employment and self-sufficiency. Section 41 is a severability clause. Section 42 repeals the sections that created the Child Welfare, Medicaid, and Oversight Advisory Committees, again, to match Senate Bill 43. And Section 43 delays the effective dates of Section 20 to 32 and Section 42 to January 1, again, to match Senate Bill 43. Mr. Chairman, that is what the bill does, and I'm glad to answer any questions.
Thank you. Speaker Osborne, thank you for being here as well. I know you gentlemen are busy right now, and I appreciate all the effort that's gone into this bill. I know that's been a lot of discussion. I know you've taken a lot of the input from several different groups, and this bill obviously looks a lot more additions and a lot of changes into this. I was hoping to have some of the folks who want to speak in opposition come next and then entertain questions, and that might be the easiest way to do this. There's quite a few people that have signed up, but I've got three that I'm going to call on to come and provide, again, some brief testimony on their concerns with the sub. I believe Secretary Friedlander is here. There he is. And also we've got Emily Beauregard with Kentucky Voices for Health. And I'm going to ask for Katrina Thompson with Feeding Kentucky. I don't know if she's here or Cassidy Wheeler, if they're here. If you'd like to come forward. And going to give each of you 3-4 minutes to express concerns that you have with the bill. Mr. Secretary, if you'd like to come to the table now and introduce yourselves, we'd appreciate that. And Secretary, if you'd like to begin.
Yes, Secretary Eric Friedlander of the Cabinet for Health and Family Services. First, I would like to acknowledge the changes that have occurred in this bill throughout this process, and also particularly in the Senate. I do want to say that certainly many of the SNAP provisions are improved, and I want to acknowledge that I greatly appreciate the work that's been done on this bill. However, I need to also then want to read into the record a letter that I sent to you all. And so if that's all right, I'd like to begin. I write today with great concern about House Bill 7. Last Thursday, CHFS joined many community advocates in voicing their concerns about this bill. CHFS and the advocates were clear that the language of this bill would increase barriers and red tape for Kentuckians most in need of health coverage, treatment for substance use disorder, treatment for behavioral health, child care, and food assistance. This would eliminate critical benefits for thousands of Kentuckians and threaten to increase existing health care, child care, and food deserts. Our concerns about these impacts on our vulnerable citizens and on the significant administrative burden House Bill 7 would create have not abated. Last time in front of Health and Welfare, we talked about the state of Arkansas. And so we looked at the state of Arkansas. And if Kentucky were to model only the additional paperwork requirements in House Bill 7, we estimate that an additional 180,000 residents could lose their health care coverage. Not only would vulnerable people residing in primarily rural areas be negatively impacted, but loss of benefits would mean over $1.3 billion would not go to health care providers across the Commonwealth. In addition, the food assistance waivers impacting single adults were last in place in 2019 for the following counties: Henderson, Davies, Callaway, Logan, Simpson, Warren, Hardin, Bullitt, Jefferson, Spencer, Shelby, Oldham, Henry, Owen, Franklin, Woodford, Fayette, Jessamine, Anderson, and Campbell. The proposal brought forward to cut benefits would impact beneficiaries in many of these same counties today, and with the 10%, actually no counties would qualify. I hope we can unite in the support for our most vulnerable residents, including those with disabilities, the elderly, and children. As we continue to make Kentucky a better place for its residents and generations of Kentuckians to come, it is important that there be a shared understanding of the impacts to our citizens of our Commonwealth and to their communities and to the Cabinet. Thank you.
All right, thank you. If you'd like to introduce yourselves for the record and go ahead and provide your testimony.
Yes, I'm Katrina Thompson. I'm the Executive Director of Feeding Kentucky. So many of Kentuckians, as we saw during COVID, are just one medical bill, one layoff away from really needing help, and these are our friends and neighbors. I had some statistics, but I want to tell you a story very quickly. Early in my 20s, I had 2 children that I was raising alone. I was a diabetic. I could not afford to pay, although I had a job, I couldn't afford to have the money for health insurance taken out of my check. I made too much money because I did work to get any services. Again, this was, 30-something years ago, 40 years ago. So I often chose not to get the little test strips to test my blood sugar. Couldn't afford insulin because I couldn't get Medicaid because I made too much money because I worked. And then at age 40, I had kidney failure and had to have a transplant. Thank goodness things have improved today, but this really exists. So I just wanted to share that with you, and I'm going to let our advocacy person speak very, very quickly also.
Thank you, Chairman and members of the committee. So my name is Cassidy Wheeler. Like Katrina said, I'm the advocacy coordinator here with Feeding Kentucky. But before this, I was a public school teacher, and so I want to speak to you today about how this bill is going to impact children in schools. So SNAP is a program that disproportionately benefits kids. 70% of households that receive SNAP have children. If this bill passes, families and kids will lose food assistance, and schools will be the ones expected to fill the gap. We know that schools are underfunded and understaffed, only exacerbated by the pandemic. As a former Kentucky teacher, I can say definitively, many students are already going hungry in spite of even having school feeding programs. So my former school district in Warren County has a high population of low-income students, many of whom are refugees or immigrants. This district was also hit really hard by the December tornadoes. 3 students lost their lives, and so many other students suffered significant losses as well. If it wasn't for their families receiving SNAP, many of these students would go hungry over weekends and evenings between their last school lunch and their next school breakfast. Though this is one example, schools across the Commonwealth are already struggling to meet their students' needs, and this bill would make it even harder. Kids can't learn, let alone thrive, if they're hungry. So I'd like to give you an example of how this bill will hurt Kentucky families from my own teaching experience. Many of my students didn't speak English. They came here as refugees, fleeing war, genocide. Their families didn't speak English either, so when my colleagues and I would call home to speak to their parents, we had to use an interpreter service. And it wasn't unusual for no interpreter to be available, so oftentimes we would have to call multiple times until we finally were able to speak with them. It was a challenge to make sure those kids got the help they needed, and sometimes the system in place to help them failed. These are the families who will fall through the cracks if this bill passes. Those who already face significant challenges either because of language barriers, work demands, accessibility, or any number of other reasons. The systems we have now are imperfect and often ineffective, and the last thing struggling families need is for an already difficult process to become nearly impossible. But that's exactly what this bill will do. Kids shouldn't worry about where their next meal is coming from, yet that will happen if you vote in favor of this bill. If HB 7 passes, families will lose food assistance. Kids will go hungry. So if you care about children, if you care about educators, if you care about the welfare of Kentuckians, you'll vote no on this bill. Thank you.
Thank you very much. Emily Beauregard, if you're here, Emily would like to come forward and provide a few comments. I certainly hope that is not your speech. All right.
No, it isn't. But it is the DCBS manual, and we wanted you all to see just how long and complicated that it is. But I want to start by introducing myself. I'm Emily Beauregard. I'm the director of Kentucky Voices for Health, and I'm here with my colleague.
Hi, I'm Kara Stewart.
And I just want to say thank you, Chairman Alvarado and members of the committee, for giving us a few minutes to testify today on House Bill 7 and the concerns that we have about how this bill would take away food and health care from thousands of Kentuckians.
What I want to think about is also, I deeply appreciate the time of so many people on this committee who I know have invested time in this bill and thinking about this. But where I still keep coming to is, why do we want this bill? We want this bill. I know that Representative Mead wants to make sure that eligible Kentuckians can get their benefits, and if you're not eligible, you don't. And I don't think that's what this bill will do. I know that Representative Mead said that he wants to make sure that kids do not lose benefits. I am confident that kids will lose benefits under this bill because of self-attestation in Section 16, Paragraph 10, where the bill says that we shall not accept self-attestation of household composition. Well, I'm a former legal aid lawyer, and I've had a whole bunch of cases where that exact thing has happened. And so what if your household composition does change? How do you prove it? Are you going to go ask your neighbor? What if you're a CHIP family and you don't want them to know? You're working hard. Maybe you're their colleague and you don't want them to know that you get benefits, because we have a lot of stigma, unfortunately. But also, there's no other way to really prove that. How many people, somebody just moved out of your house, and so now we're going to absolutely not accept that? That means that people who don't have a lot of documentation in their lives, and think about who that is, people who don't have homes, they don't have a whole lot of documentation either. So we're going to make it impossible for someone to prove that they don't have a home, because how do you prove that? That will cause families with children in their homes to lose benefits. And that is unacceptable to me, and I hope it's unacceptable to you. Another section that I think actually creates opportunity for fraud, which I think is the exact opposite of the purpose of this bill, is in Section 16, Paragraph 10. Wait a second. Yeah, Paragraph 11 on page 17, if you want to follow along. And the word may in Paragraph B, which says you may consider fluctuating income data, that is fundamentally less accurate. If you have, a farmer, that's a real easy one. What does their income come in? When they sell their crops, when they sell what they're selling. Well, that isn't happening every 2 weeks. So you're fundamentally getting less accurate income information if you are relying on the most recent only. You're creating an opportunity for people to file and to offer documentation when they know that maybe it will be eligible. And, I don't know that Kentuckians are there trying to do that, but I would like to make sure we're not creating a system where we're creating that pathway and incentivizing that. The other piece is that Section 5 Community Engagement Program, which is modeled after the SNAP work requirements. They're solving the wrong problem. I know that most people in here know that the majority of Kentuckians with Medicaid are working. In fact, nearly all Kentuckians with Medicaid who are able to work are working. The Kaiser Family Foundation has found that at most 2%, and others as low as 1.2%, 2% of people who are able to work and aren't, we don't know why. Who are the other folks? They're kids. They're in nursing homes, and they're disabled. The rest of the other folks are working, but where are they working? You see them every day. Anytime you exchange money, that person's probably eligible for Medicaid. At the fast food restaurant, at the grocery store, 1 in 4 people that make your food are on Medicaid. That's just a reality. They're not getting paid enough. So I don't think it's solving the right problem. And I know that you all are critical thinkers, and I want you to think critically about this and make sure that this bill solves the problem that you're looking to solve.
Thank you very much, ladies. Appreciate your testimony and coming today. I think we've got some questions. We're going to entertain some from the committee now. Senator Givens, I don't know if you have questions for the Speaker and Speaker Pro Tem.
I do, but let me start, if I could, first with Secretary Friedlander. Mr. Chairman, I'll be brief.
Sure.
So, Secretary Friedlander, in the work the Cabinet does, there's lots of latitude for promulgating regulations, and you and I have lots of conversations over those. And thank you for being here today to testify on this legislation. In a situation where these processes of attestation and self-attestation and the application for vitally needed services at the times that citizens in our Commonwealth are seeing difficulties, we need to get this right. We so do. So briefly share with the committee, what are the processes for the Cabinet to regulate individuals as they apply for these services and or for entities like hospitals that assist people in applying for these benefits? What's the process the Cabinet uses to police that the right people are getting the right services?
Thank you for that question. And yes, there are many different processes to do that. We do when people report that someone is getting services that are not appropriate. We will investigate. We have what are called predictive analytics, information systems that will look at, for instance, SNAP purchases. We use those when there's a flag. We need to investigate. We actually lost a court case within the past year about only using the predictive analytics. We really do have to do an investigation. So all of those are the kinds of things that we do when people sign up for SNAP. Now, Medicaid, we have longer terms when folks sign up. We do use some presumptive eligibility and have since the 90s. And the reason that is so concerning to me and to the Cabinet, I can tell you as we have moved to a more virtual environment, I can give you, and the reason I have a better way to quantify it now than I did before, is I can point to our call volumes beginning in January of 20 and to where we are in 2022. And it's why I'm very concerned with the additional paperwork requirements. I believe it will overwhelm our systems.
So as we have entities that are assisting, and I think in the case of a hospital or long-term care facility,
Yes.
assisting is the right term.
It is.
These individuals to enroll, there's a shared benefit there. And let's not kid ourselves. We need to get this right. These are taxpayer dollars. Help me to have some comfort that we're doing it well.
So within the hospitals, and also then I'll do hospitals and then nursing facilities. Is that all right?
Please.
Hospitals first. Someone comes into a hospital and does not have insurance, and they are in an emergency room. And the hospitals have a very expensive ER stay, acute stay. They will begin the process for Medicaid eligibility. That helps the hospitals stay afloat. It helps with the costs. And then that individual can get taken through the process to become Medicaid eligible. It is something
If they qualify.
If they qualify.
If they qualify.
If
We're
they
not presuming
qualify.
they qualify. They have
Correct.
to qualify. So there's not a
Correct.
presumption other than providing that first service.
Yes.
Okay.
Yes.
Which the hospitals are required to do.
Yes. In nursing facilities, probably the most difficult eligibility standard to meet, it's like our waiver standards. They are particularly difficult when you have a person who is elderly, and this is new. This is since the pandemic.
Sure.
We allowed for some of this within nursing facilities. Yeah. What it does, when you're looking for assets, cars, stocks,
Sure.
homes, those kinds of things, that can take a long time, particularly if someone perhaps has a memory issue and not a lot of family. It can take up to a year. And so this helps with the nursing facilities as they go through the process of finding all the assets. What happens in that case is if assets are found, Medicaid then issues essentially a bill for those assets. Like when somebody sells a home, you have to get down to under about $2,000 worth of income and assets before you're actually Medicaid eligible.
And I'm sorry to cut you off.
Oh,
but-
no,
but
that's
I've got
fine. I'm
some
sorry. It's
questions for the
complicated.
sponsors too.
Yeah.
Last quick follow-up. So in a situation, and this may be more on the SNAP benefit side, where we have a question of eligibility, and it's being investigated by the cabinet, is there a time frame? And if we run out of too much time, help me to understand a family that's truly in need, and an investigation ensues, and does it take 2 weeks? Does it take 3 months? What happens along the way? Does the family lose benefits until how does that work?
Yes, and I would want to have one of my eligibility experts here, so I'm gonna
You be
answer.
that person for just 30 seconds.
I will try, but
Okay.
know that my detailed knowledge here. So yes, if somebody finds that like they need more information, which is often what happens in order to to maintain eligibility for SNAP, they have a certain number of days to get that back to us. If they don't, they lose coverage. If there's an investigation and we send a letter, there is a whole hearings process, 13B hearings process that they can go through. We had been pretty far behind on that process, so it could take months and months to finish that process.
And
We have
someone
caught
keeps
up.
their benefits until you process it.
I don't believe so, but I will have to get back with you on that.
Okay.
I'm sorry.
Get back to me soon
I will.
on that
Absolutely.
one.
Yes.
We go on the floor tomorrow, and we need to get that one right.
Absolutely.
Thank you.
You're welcome.
Chairman, if the two gentlemen could come back, I'll be as
Certainly.
brief as I can.
Thank you.
Speakers Osborne and Mead. We've got Senator. We've got a couple other members who have a few more questions as well.
Thank you, Mr. Chairman. I will be brief. Gentlemen, thanks for your work on the legislation. I think we share a lot of the same concerns, and you heard my line of questioning with the Secretary. Speak globally, if you would, for just a minute, Leader Mead and Leader Osborne, about the goal here, and I think we share that same goal.
Yes, you're exactly right, and the goal is to make sure that the folks who are truly need these benefits are receiving them, and that we are cutting down on fraud and cutting down on those who are ineligible, so that we make sure that those assistance programs are secured for those who truly need it.
Let's follow up on that, Senator Gibbons. I think that we can all acknowledge that these programs are incredibly important to those that rely on them. I think we can probably also agree that there's never going to be enough money to truly provide that very necessary safety net underneath the most vulnerable. And I think to acknowledge that there's never going to be enough money also brings us to the point that we have to acknowledge that we can't allow fraud to continue unchecked, or certainly without trying to identify it at every opportunity, without placing undue burdens on those that need it the most.
Well said, and I think the three of us have worked long enough in government to know that no system is going to be perfect. We're going to have some fractures in the system where we can't get it all perfect, but as long as we do try to make tomorrow better than today, I think we're moving in the right direction. Last quick question, specifically to the page 13, and this is one, I start at the place the two of you start at, but I'm looking at the stricken language at the bottom of 13 as it relates to the unemployment rate. The previous language gave the cabinet some flexibility with regard to severe declines in particular counties. And I think from conversations we've had about policy in the past, we don't have a good, solid regional unemployment rate. That's hard to nail down as a regional rate. I'd love to talk with you afterwards maybe about some possibilities that we can find some way to give some leniency to the cabinet at certain times, because as the two of you know, and others, we can't call ourselves back to address individual things. Speaker, you and I are both in concert. We'd like to be able to come back when we need to, and we're still working on that. But when we're not here, if something pops up and they can't obtain authorization from the General Assembly, or is there a mechanism? Let me back up. Maybe there's a mechanism you see, Leader Mead, when we're not here for them to obtain authorization from us.
Yeah, I mean, if you look at that language, Senator Givens, it says that they shall not accept or seek a renewal of a waiver unless there's an economic downturn resulting in an unemployment rate of 10% or more, and the cabinet determines an increase in employment rate in a particular county to be severe enough for necessity of a waiver. We've pretty much just said the same thing, only using the 10% in both places in the above two, subsection 1 and subsection 2.
We'll talk offline about some other thoughts and see where you stand. Let me conclude by saying thanks to both of you for your leadership, Leader Mead especially, the work that you've sat with me and you and I have done in this legislation over the course of the last 2 weeks. Thanks for being open to my input. Thank you, Chairman.
Thank you, Senator. Senator Howe.
Yes, gentlemen, I can direct my question at you too. Secretary Freelander discussed the staffing problems, and I know from prior discussions they're having difficulty staffing everything now. With an implementation, have y'all looked at whether we need to graduate implementation in some way? We always talk about gaps in funding when we're talking about businesses. I'm concerned that we might create some sort of employee gap in here where we have all these additional requirements, and putting those on a staffing situation that's already understaffed and with no real way to ramp up the number of employees and to get them trained in time to implement.
Yes, I appreciate the question. First of all, what we did throughout the bill is, as we had listened to the cabinet and where they said they were going to need additional employees to do all these additional checks and things like that, we've removed all those additional checks. There are none. All they have to do in here, in 2 sections now, it says that through the normal course of business. So just as the Secretary was talking about those red flags that they see and they have to investigate, that's normal course of business. Now all we're doing is we're adding penalties when they find that there is misuse. The other part would be for the community engagement program that would be developed. That community engagement program for SNAP was already in effect prior to COVID. So that would just go back into effect. They were already running it. They already knew how to run it. So that shouldn't be a big surprise to them. The next thing is on the community engagement program is we actually changed the language. There are no work requirements. It's a community engagement program that the cabinet can develop in any way they want to. Matter of fact, Secretary Friedlander has said, I think to the chairman a couple of times, that he's in favor of a community engagement program within that program. So they can develop it however they see, and the language has just been changed to say that they will do it within federal law.
One quick follow-up.
Quickly.
Thank you for walking me through that. So it's safe to say that everything's already in place. You're just putting more accountability steps in with the infrastructure. It's already in place. It won't need any real new infrastructure.
Yes, sir. That would be up to the cabinet on how they develop that program.
Thank you.
Thank you. 2 more questions. Senator Adams.
Yeah, and this may have already been answered. Thank you, Mr. Chairman. I was kind of confused when I saw the first fiscal note and it was high, and then you all removed several sections that you felt as if would have a big fiscal impact, and then the fiscal impact statement grew. And I know you just went through some of those with Senator Howe, but it just seems counterintuitive that the fiscal impact statement from the cabinet would grow instead of decline. I didn't know if you wanted to comment on that.
Well, I'm glad you asked that, Senator Rocky Adams. I have 2 fiscal impact statements here. One is from 2 years ago. One is the current one that is with this committee sub. And I actually found out about this one with the committee sub from the press. I had 2 members of the media call us on Thursday evening to tell us what the numbers were. Now, it may have been given to LRC and they just hadn't gone through and compiled it yet to give it to us. But I thought it was interesting that the press contacted me to tell me what the fiscal impact statement was. But there's some major differences in what was given 2 years ago and what's given today. And I'm just going to point out one section because it's in section 2 or it's in the first part of the fiscal impact statement of this current one. And it says the Department of Community-Based Services will need to hire an additional 300 field support specialists and 60 case managers for increased SNAP compliance and oversight. With the added restrictions applied to SNAP and EBT cards, especially with monitoring SNAP trafficking activity in this legislation, costs are estimated to be a minimum of $25 million annually. Section 2 of 2 years ago, almost the identical language. It's estimated that the provisions of Section 2 will cost $1 million for additional staff to monitor EBT cards for cash withdrawals and investigate cases when cash benefits are being used in violation of Section 3 of this legislation. Applying the blended match rate of 30% general fund and 70% public assistance programs, there would be a fiscal impact of $300,000 in general fund and $700,000 in federal funds. That one section, identical language almost, a difference of $24 million per year. So right there in the fiscal impact statement, if it's actual $1 million over the 3 years that they gave us, that's $72 million in savings. I will also say that another section of this fiscal impact statement, it says the Office of the Ombudsman Administrative Review will need to hire an additional 50 hearing officers and attorneys. Costs are estimated to be $4 million annually. In their original fiscal impact statement, there was no cost for that. They felt that they could do it with the staff that they had. There's another, over the course of 3 years, another $12 million. And if these numbers are true, the $4 million here, they're saying that there is an abundance of fraud in this system that they're going to have to deal with by hiring 50 new hearing officers and attorneys. The most of the cost in this note is for the implementation of a community engagement program, which I've already said to Senator Howe, already had SNAP community engagement in place in 2019. As I spoke to some members that were affiliated with the national HHS and with some members of previous administrations, and we even contacted Arkansas this weekend, many times you can figure that if someone's on SNAP, they're probably going to receive additional benefits like Medicaid. So those people would already be covered under those community engagement programs. But there's another population of people that would only be on Medicaid. Again, if the cabinet's numbers are right in that fiscal impact statement, they are saying that there is a significant number of able-bodied adults with no dependents at home who are able to work but are simply not working. That is the only reason you would need all that additional staff to enforce this bill.
Thank you. Senator Berg.
Thank you, Mr. Chairman. My question goes more to the presumptive eligibility, because this is an area that is very near and dear to my heart. My understanding with presumptive eligibility, which was expanded during the pandemic, is that it has basically allowed most of our rural hospitals to keep their doors open. Because this, when a patient shows up in the emergency room, with EMTALA regulations, you cannot turn that patient away. You have a legal obligation to take care of that patient. And the emergency rooms do that. They have to do it, and they do that. But without this presumptive eligibility, those patients, once they are discharged either from the emergency room or the hospital, have absolutely no way to get follow-up. And what that does, and we heard from one of the women who testified this morning, an ounce of prevention is worth a pound of cure. These, what started out as poorly controlled diabetes ended up literally with a kidney transplant, which is, the difference in cost is exponential. So when we're talking about limiting presumptive eligibility, I get extremely worried. Can you tell me how many complaints of fraud for presumptive eligibility have been filed in the last 12 months, 24 months? What numbers are we talking about, please?
Actually, I can give you some estimates, but first let me answer your question. Presumptive eligibility is not in this bill anymore because the Hospital Association gave us numbers, or gave us language that held themselves accountable by doing some additional requirements. Also, self-attestation. If you, as was said in someone mentioned in section 16 a while ago, that self-attestation was taken out of here and that children were going to lose benefits. It's easy if you only read the first part of that section and don't continue on down where it says that we are exempting nursing homes, long-term care facilities, and hospitals licensed under this licensed under the chapter the KRS chapter, which means that self-attestation's really gone out the window in this. The only difference in this is that the cabinet now must do the self-attestation study prior to the approval as opposed to after.
May I follow up, sir?
One more briefly, because we need to take
Okay.
action on this bill.
But basically, that between and betwixt is what will keep these people from having follow-up appointments in a timely manner. Because if they get eligibility for the hospital, so the hospital's covered, but then they lose their presumptive eligibility until the cabinet has the time to confirm it. When you're talking about somebody who came into the emergency room with, let's say, uncomplicated pancreatitis, and they send him home on clear liquid diet and maybe some oral antibiotics to follow up with a primary care physician within the next week, and that doesn't happen. And then you have somebody come in 3 weeks later with massive hemorrhagic pancreatitis, and you're talking about hundreds of thousands of dollars worth of bills that we're going to cover because that's what we do as a state. I just think this is very, very short-sighted thinking. So I'm bringing that up as my main concern.
And again, I would say that your comments are based around self-attestation where it specifically says that all those are exempt.
Senator Carroll.
Thank you, Mr. Chairman. We've talked about the purpose of the bill, and that's clear. And I guess just to close this out, this is passed, it goes into effect. How do we gauge success? What are the metrics? 5 years from now, how will we know if this succeeded or it didn't succeed?
The cabinet would need to keep track of the data on that, and I will go back to giving you some numbers as Senator Berg asked a while ago for some, how do we know that there is misuse in this system of presumptive eligibility? First and foremost, several states have kept track of presumptive eligibility throughout COVID. And what we have seen, if I can find my sheet here, of those states that kept track, Indiana had only 25% of those who were determined eligible who actually were eligible. California had 23% that were eligible. New Hampshire was 33%. West Virginia was 35%. If Kentucky is even anywhere close in that range, there will be significant amount of money that the taxpayers will save due to those who are not currently eligible. I've been working on this bill with the UK Gatton College of Business and Economics, and in their study in 2016, they showed 73,000 who would be ineligible right now on the roads for Medicaid. Since that time, they have been continuing to update and try to do estimates to keep track. Today, he emailed me last week and said, of those that are on Medicaid improperly, there will be a cost to the federal government of $1.86 billion and the taxpayers of the state of Kentucky $186 million per year. That is their estimate right now, with Kentucky ranking third in the nation, the biggest increase in improper Medicaid enrollment since the passage of the Affordable Care Act. If we just make a minor improvement in this area, we're going to see significant changes and significant savings.
Thank you. Appreciate your work.
Thank you very much. All right. I think we've had a lot of questions, a lot of debate around this topic. Secretary Friedlander, do you have an answer for Senator Givens' questions? I'm being told that you might have an answer. Very quick. Please, at the microphone, just very brief with your response.
Yes. They keep receiving benefits through the hearings process, and it is a federal requirement. And according to Jason Dunn, who sent this to me, we already are a very, very high state in terms of disqualification from SNAP, maybe one of the highest in the Southeast. Thank you.
All right. Thank you very much. All right. At this time, we'll entertain a motion on the bill as amended. We have a motion. Is there a second? We have a second. Any other questions? If not, Madam Secretary, please call the roll.
Senator Rocky Adams. Senator Berg.
No.
Senator Carroll.
Aye.
Senator Givens. Senator Harper Angel. Senator Howe. Senator Kerr. Senator Meredith. Senator Nemus,
Aye.
Senator Wise, Chairman Alvarado.
Aye. The matter passes by a count of 9 yes votes and 2 no votes. Congratulations, gentlemen. Will be reported favorably to the floor of the Senate. At this time, I'll entertain a motion to roll the sub and the amendment into a new substitute. We have a motion. Is there a second? A second. All those in favor, please signify by saying aye. Aye. Any opposed? All right. So that it has been rolled into a new sub. I also have a title amendment. We'll entertain a motion on the title amendment. A motion and a second have been made. Anybody? Well, all those in favor, please signify by saying aye. Aye. Anybody opposed? Very good. All right. The title amendment has been adopted as well. Thank you, gentlemen. Appreciate you all very much.
Members of the committee.
All right. And last on the agenda we have here is House Bill 28, an act relating to immunization disclosure. The sponsors, Representative Savannah Maddox. Representative Maddox, if you'd like to come forward, introduce yourself for the record, and please begin your testimony.
Thank you, Mr. Chairman and members of the committee. I'm grateful for the opportunity to present to you today. I am Savannah Maddox, and I represent Kentucky's 61st House District. I have before you today House Bill 28, which would provide statutory protections against mandatory vaccination. As I've traveled across the Commonwealth over the course of the past 2 years, there has been no issue that has come to the forefront like this particular issue, in so much as Kentuckians want the freedom to be able to decide for themselves whether or not to receive a vaccine without being forced or coerced by the government or any instrumentality of government. This piece of legislation passed 71 to 22 out of the House, and it's a short bill, a mere 5 pages, and I would like to just briefly go over each section for what it would do. In Section 1, it would disallow public entities from requiring an employee to disclose their immunization status with regard to COVID-19. Section 2 would apply to public universities, very same concept that they would be disallowed from requiring students and staff from having to disclose their immunization status. Third section is that the government cannot require a vaccine or a vaccine passport or any other type of document. So essentially, this component would disallow any type of vaccine mandate. And lastly, Section 4 would allow for parents to decide for their own school-aged children whether or not to receive a vaccine, given that they can opt out on the basis of conscientious objection. And again, I've told you what this bill does, and I would also like to emphasize what this bill does not do. This bill is not intended to debate the merit or non-merit of receiving a vaccine or in any way, shape, or form discourage or encourage anyone to do anything. It comes down to the fact that Kentuckians are capable of making good decisions for themselves and their families when it comes to their health care without any undue influence, force, or coercion from the government. Thank you.
Very good. All members, I think we've got also a couple of letters in our packet that we've received, so that have been asked to be placed there. We've got some folks that are going to speak against this bill that are here today. I believe Mr. J.D. Cheney, are you here? If you'd like to come forward, I also have Dr. Brittany Welch with the Kentucky Nurses Association and Marcy Timmerman. If y'all would like to come forward, please, and if you could introduce yourselves for the record and begin your testimony.
Thank you, Mr. Chairman, members of the committee. I apologize for the attire today. I thought I would be over in the Lexington office, but saw your agenda, Chairman, and thought it would be best to head over here. Those of you that worked with the Kentucky League of Cities, and most of you on this committee have for a long time, especially if you sit on Senate, State, and Local Government Committee like Senator Nemus, Senator Harper Angel, and Senator Alvarado, and others on the committee, know that one thing about our organization. We're consistent. And we've been consistent on the line of home rule, or the fact that local decisions are best made at the local level. House Bill 28 started out over in the House as an employer preemption measure. As it was amended, it became much more targeted for government in their role as employers. And so my organization obviously feels strongly that any piece of legislation that's introduced ought to favor the idea of local control. Local officials are setting in the best situation to make decisions for their employees and for their constituents, and this prevents that. even though it's related to a very isolated issue. There are, and the sponsor has been so gracious to acknowledge this argument because I think there's a lot of philosophical agreement with the idea among my membership that employers, city government employers, probably wouldn't be making this decision. In fact, our organization opposed the proposed mandate from the Biden administration that impacted our cities. We participated with the Attorney General by filing affidavits in that case. So we've been consistent with regard to our opposition of a mandate and feeling that this is a decision best made at the local level. And the way this bill is drafted, it targets that ability of local officials to govern the running of their communities, their cities, which are places of employment. As a result, we would ask you to vote in opposition of House Bill 28 as it was amended.
Ladies?
Good afternoon. Thank you, Mr. Chairman, for the opportunity to speak regarding House Bill 28. My name is Dr. Brittany Welch. I'm the Director of Clinical Education for nurses throughout Kentucky, and I'm responsible for clinical placement of thousands of students. I'm also the chair of the Governmental Affairs Cabinet for the Kentucky Nurses Association. I'm here today speaking for and representing 89,000 nurses, including 42 nursing schools and 97 nursing programs and their deans and directors throughout Kentucky. As you well know, it is critical to address the nursing shortage now. Currently, Kentucky has a 12 to 20% nursing shortage, and it's projected that we'll continue to experience a shortage of over 16,000 nurses by 2024. House Bill 28 prohibits employers and post-secondary schools from inquiring about vaccination status. This would severely alter the ability of nursing schools to facilitate clinical placement. The Kentucky Nurses Association strongly opposes House Bill 28, along with the Kentucky Hospital Association and other healthcare organizations. Hospitals and other clinical sites that receive federal funds will not be able to place nursing students and accompanying faculty if the students and faculty are unvaccinated or their vaccination status is unknown. If an unknown vaccination status puts patients and families potentially in harm's way in clinical sites, it may jeopardize the clinical sites of not receiving funding. If nursing students cannot be placed at a clinical site, they cannot receive the required clinical education to be proficient nurses. They cannot graduate from nursing school, they cannot take the NCLEX, and they cannot be registered nurses or licensed professional nurses. This bill exacerbates the nursing shortage and puts patients and families in danger. The Kentucky Nurses Association, its affiliates, the Kentucky nursing schools, deans, and directors, we're asking you not to pass this dangerous bill out of the committee as written. I can take questions, but if it must pass, then we are strongly requesting that nursing students and nursing school faculty be exempted from this bill.
Thank you, Dr. Welch. Ms. Timmerman, very briefly, any comments you'd like to make?
Yeah, my name is Marcy Timmerman. I'm speaking today as a citizen, not as my employer, so I want to make sure that's clear. Is the mic on? Okay. Oh, there it is. Sorry about that. My name is Marcy Timmerman. I'm speaking as a citizen, not for my employer. So I did take off my badge and I am off the clock. Vaccine status information feels personal, but it has very public implications. That's why certain entities require that information. 874,000 Kentuckians have a disability. I think all of you have heard that from the 874K Disability Coalition. I'm not here representing them today, but I have been contacted by many of their members who are very concerned about this bill. The people who have contacted me and begged me to stand up for them today do not want you to pass House Bill 28. I hope they took my advice and actually contacted you themselves. That's always best, right? But I'm here trying to explain a little bit, very briefly, why we are concerned about it. They're scared that they're no longer going to be able to trust their doctors, their nurse practitioners, their cancer care unit, their teachers, or their dorm mates to keep them and their families safe. Those who cannot do so are already talking about taking their health care across the border into other states. What do I have to do? Where can I go that doesn't have this law, Marcy? What can I do? I'm worried about our border hospitals and our rural hospitals that are on the borders or near those, that they're going to lose that very expensive care that helps feed their coffers, cancer care, heart surgeries that are elective, care like my own. I am a person with an invisible disability, and I take very expensive medication and sometimes receive very expensive treatments. What will I have to do if I have to leave the state? People who are against vaccines can make their choice. There are personal protective measures that can be in place when they care for someone like me, but those can only be enforced when the provider knows that they are unvaccinated. I want to be very clear about that. Not requiring that information jeopardizes not only my trust, but also my life and the life of so many people I've heard from. This bill is unnecessary. It reinforces the message that these people with disabilities hear over and over again, that we are not valued, we are not included, and that our rights do not matter. I would argue the opposite. Thank you.
Thank you very much. Appreciate that. All right, we have a question from one of our members, Senator Byrd. No questions. Any questions from members of our committee? I have a few questions for Representative Maddox. I'd like to come forward. And I'm just going to ask you, how many yes votes do we have in this committee for this bill here today?
Would you like for me to disclose that individually or publicly?
No, I'm saying
I was under the impression as of last week, whenever I approached the chairman, that the bill did not have a sufficient number of votes, but since that time it has gained a bit of momentum. And I also have some remarks I would like to make about some of the commentary up here when the time is appropriate,
Sure,
Chairman.
I'll let you make those now.
Sure. Yes, no aspect of this bill precludes hospitals from abiding by the federal mandate in so much as public universities are not tasked with enforcing that. The healthcare facilities are. So if you have students that are being placed, they would have to abide by the requirements that are in place, the Medicare and Medicaid requirements, unless they had a religious exemption, medical exemption, or something that was governed at the federal level. But, no aspect of this bill precludes hospitals from doing that. It's public universities.
Okay, very good. Also, so I was asking how many yes votes. It sounds like, I don't know if you have a definitive number in your mind or not. I guess the follow-up question is, have you spoken to all the members of this committee about this bill?
I've spoken to a great number of them about this bill.
I know that you haven't spoken to all of them, at least. And so the question there becomes, why not? I know you had reached out, asked for this bill to be heard. And you're right. Brief text message was, we don't have the votes. So I'm curious if you have them. Customarily, if a sponsor asks for a bill to be heard, the presumption is that you have the votes for it to pass. And so typically if it's an important bill, that would be the thing that I would hope to have coming forward. All right, very good. Any other questions from members of the committee? If not, we'll entertain a motion on the bill. You have a motion on the bill. Is there a second? You have a second. All right. Any other discussion or questions? Madam Clerk, please call the roll.
May I explain my vote, Mr. Chairman?
Please proceed.
I'm going to be a no vote. House Bill 28 puts the University of Louisville Medical Center in direct conflict with federal law. And I would need to cast a no vote because without an amendment being offered to fix this conflict, it's just too precarious for my university.
No.
Senator Carroll.
Explain my no vote.
Please proceed.
Mr. Chairman, it's easy to make policy in retrospect and looking at what has happened. What is difficult is to make policy in foreseeing the future. There's no way we can know what COVID will bring, what the next variant might be, how important it is that people know someone's vaccination status. That could mean the difference between life and death depending on the variant and how deadly it is. And it's for that reason and the reasons mentioned by the opposition that I vote no.
Senator Carroll. I'm sorry, Senator Givens. Senator Harper Angel. No. Senator Howell. No. Senator Kerr. Senator Meredith. Aye. Senator Nemes.
Aye.
Senator Wise. Aye. Chairman Alvarado.
I'll cast an aye vote for the sake of the sponsor today. Although I've got some of the concerns, some of the testimony that's been made, but by a count of only 4 yes votes, the matter fails in committee. Very sorry. Thank you very much for your testimony, for all who came and testified today. Any other issues coming before this committee? I do want to take a moment. I'm not sure if we'll be meeting again or not going forward. So if we don't, I want to take an opportunity to thank our wonderful staff in this committee. A lot of hard work goes on behind the scenes for, yes, absolutely, applause. They do a lot of work. They'll be doing a lot of work here in the next few days also for amendments and lots of the things that come forward. So I do appreciate all of that, and thank you all so much for all your hard work. No other comments? We stand adjourned.